believe there is always this tendency for us to forget that a day will come when we shall all go back to our Creator, and this can only be through death. Death is a reality which comes like a thief in the night when we do not know. And so when that moment comes, what happens to all the properties we have worked for so long? Good evening, televiewers. Welcome to another edition of the program. We are sending you salutations from the studio of Divine Mercy Radio Television Service here in Boya. You will bear with me that families have been turned apart because of fighting here and there on who is to inherit what property after the death of one of their loved ones. And some go to the extent of taking away their lives, or in the course of fighting, they lose their lives because they want to inherit a particular property. As those who are living, what are some of the informed decisions that we can take to ensure that some of these chaos do not happen when we are no longer there? And also to ensure that the right persons owns the inheritance. You can let us know your opinion as the program unfolds by either sending us a WhatsApp message or a text message using the number you shall be finding on the screen, or you can follow us on Facebook, where we are streaming live at Divine Mercy Radio and Television Service. The program today is Understanding the Law of Succession, Last Will and Testament. I am FOMUCHA Mirabelle for presentation, and when we come back after the transition, we shall be welcoming the guest on the program today. Once again, good evening and welcome to the program Issues, coming to you from Divine Mercy Radio Television here in Boya. And the program we are talking about, or the topic of today, is understanding the law of succession, last will and testament. And it is a privilege to have here with us someone who has dedicated his life in protecting the rights of humans. He is the branch head of the Cameroon Human Rights Commission for the Southwest region, and he is also a board member of Elections Cameroon. Let us welcome on board Barrister Tambetiku. Barrister, we are so happy to have you today.
It's my pleasure to be here once more.
Thank you so much. Besides your busy schedule, we are happy that you created time to be on the program, all in a bid to educate the public. Now we are talking about understanding the law of succession. What is the law of succession? Can you kindly give us an overview of this?
By succession, we are referring to universal succession.
Okay.
There are two kinds of succession, namely succession upon death and succession upon bankruptcy. Here we are concerned with succession upon death.
Okay.
Every legal system has rules governing a man's property upon death.
Yes.
These rules answer two questions: who takes over who receives somebody's property upon death?
Upon death, okay.
The answer is related to rules relating to testate and intestate succession. By testate, I mean someone who dies leaving behind a valid will.
Okay,
I must emphasize the word testate, someone who dies.
Okay.
You may leave a will which is invalid, and that comes to the next leg or prong to our
discussion. Yeah.
To die intestate, meaning that you have died without leaving a will, or the will you left is invalid in the eyes of the law.
So there are two types. Either you die intestate, which means that you die without a will, or you die testate, which means you die with a valid will.
Which in that case is dealt with now at the level of grants of property.
Okay.
But without a will, intestate, then you can go for succession strictly succession.
Succession.
Yes.
And from what you explained, succession is actually who takes over what after the demise.
About acquisition.
Okay, of property.
Succession itself is about acquisition.
Okay.
You know, because someone has died. So you are either getting letters of administration or you have been made the rightful heir.
Okay.
By virtue of a valid will.
By virtue of a valid will. And so what actually is a will? What's a will?
A will is, simply put, is a document which gives instructions on how your whether property, your rights to your pension, your movable, immovable property, rare and personal assets, how they will be dealt with after your death. And this will is one of the characteristics is that it is ambulatory, in that it can be revoked and it can also be altered at any time. So the character a will has is that it speaks only after the death of the testator.
Only after, which means that a will cannot be made public if, for example, someone is seriously sick and say, okay, I want you to know who owns what before I die.
It's not possible.
Not valid.
It's not valid. It's not valid. It is valid only, or it has a force only when the testator dies. So whatever is there, since it is ambulatory, it means that the testator has unfettered discretion to alter or to change whatever provision of the will at any time. So that will only has life.
After death.
After death. Otherwise, it's a dead will.
So a will is dead until the person or the testator
dies.
Yes. A will is dead until the testator dies, which means that the will starts living only after the person who wrote the will has died.
Otherwise, it remains a piece of paper. It speaks only after the testator dies.
Oh, that's very serious, and that's a good one there. And let us find out, are there different forms of will? Or first of all, is a will different from a testament? Because we'll hear of last will and testament. So
no, it's the same. You can call them invariably testamentary dispositions and so on. Yes, because you are saying this is a last will and testament of Mr. A B, C, D.
Okay.
Because they assume that probably some other wills must have been made. Then you can, because it's called the seal, it's also a part of you making alteration. So when you say this is the last will and testament of this, you are actually saying that this is the will.
Okay. And are there different forms of
it must, the fact we are talking here of validity.
Okay.
The will must be written and must be signed by the testator, and of course in front of witnesses.
The will must be written and must be signed by the testator, which means that if someone dies and I bring a recorded video of that person who explains how he or she wants the property to be distributed, it's not going to be considered a will? No,
those are issues of customary. You know, somehow they can be dealt with at the customary level. But the High Court doesn't actually pay regard to such details by virtue of section. In fact, the starting point, we must start by admitting that Cameroon does not have a special legislation on probate. By virtue of section 11 of the Southern Cameroon High Court laws of 1955, English relating to probate are admissible in this part of the country. By virtue of section 27, sub 1 of the Southern Cameroon Court, which enjoins the High Court to observe and enforce the observation of native laws and customs which are not repugnant to natural justice, equity, and good conscience, or incompatible with any laws enforced at the time.
Okay.
Yes, so those details the courts are precluded also by the virtue of section 27 sub 3 of the Southern Cameroon High Court laws from dealing with customary law in transactions which are not familiar with native laws and custom. Section 27 sub 3 of the Southern Cameroon High Court laws. So by virtue of that, what we are saying is that a will must be written, a will must be signed by the testator. It is the English law that applies. In fact, judicial support of this proposition is found in the case of Atira versus Akanke, 1944 case, where a Muslim made a will which was disregarded under English law because of some abnormalities. The witnesses signed, but did not sign before themselves and before the testator. And the High Court rejected, even though there was contention that the will should be judged under the customs of, under the Muslim traditions. Yes, the High Court rejected that.
Wow.
Very interesting case.
Very, very interesting. And so, how do we go about the institution of a will? Because since you say that a will must be signed by the testator, it means that there are some legal processes which are involved in this.
The truth about it is, laymen are not conversant with this because it deals entirely with the law. It's not about you calling one person in the quarter, say, look, when I die, no, those things, people should take away this. And these are the things that have brought a lot of confusion within our community.
Exactly.
Yes, I sit in a human rights office, I see these things on a daily basis. We are saying that people should go to lawyers who are versed with the procedure to draft them a will. And they, of course, they know the procedure of other, if they can choose or elect to file at the probate division, the High Court, or they keep. Nothing precludes one from keeping a will and bringing it in court when it is needed. But it is safer to keep at the probate division.
Okay,
yes.
Not in your home.
Not in your home, because what if it is needed in court and the person who is keeping
it's not there,
or the lawyer misplaces it? So there is a risk in keeping it, but there's nothing that precludes you from doing that.
Which means that in the process of instituting a will, you must get to a lawyer and you express yourself about what you actually want to get into the will.
Yes.
And then, do you need some witnesses? And
witnesses must be there to attest, and the witnesses must be present in the presence of the testator.
Wow. So let us look at the practical.
And the witnesses also must be of sound mind, just like the testator.
So how do you know that they are of sound mind, barrister?
Of course, you will know that if somebody is of sound mind, you don't need to be told. The lawyer will be able to tell that this man is not of sound mind. Or if the testator himself is not of sound mind, he cannot make a will, just like an infant cannot make a will. Yeah. But when it comes to attesting, the law is not similar like or analogous to making a will. The law does not tell who can attest, but practically it is good to avoid children and people of unsound mind.
Okay.
As mentally deranged people should not be seen attesting.
Okay. Which means when you talk about not having children being, how do you call it in law? Is it attest what?
Attest.
Attest a will. You should not have children attest a will, and which means below 18. Yeah,
below 18, but the law does not preclude someone of 17 years to come and attest to a will.
Okay.
But it's not the same like the law limits that only people who are matured of a certain age should make a will. You know, but when it comes to attesting, you keep away children and very old people also who may not understand the technicalities.
Okay, so I'm just curious, is it okay for me to bring, for example, someone wants to die and the person says, okay, I want my child to attest my will? Who has the authority to be a witness to a will?
Well, the point is, if you are talking about a will, a testator who wants to make a legal will,
yes,
we are saying that there must be witnesses. irrespective of who you bring as a witness.
Okay.
It is not, there is no
boundaries.
There's no boundary. You're just witnessing what you are, not the one making the dispositions.
Okay.
You are not giving the testamentary dispositions are made by the testator, not by the witnesses, but they must witness that this is how you wish your things, to bequeath your property, okay, your money and whatever. Yes.
So in a situation where let us look at the practicalities on the ground. We have parents who are not educated, and just like you said at the beginning of the program, many people do not know about this, but they are willing to actually do a will. So if you're in a village and you think you keep a will and you don't have